Okay, let's unpack this. We are diving into, well, one of the most complex and frankly most difficult legal problems in tort law. We're talking about the standard of care and the resulting liability when the defendant suffers from a significant mental impairment. Think advanced Alzheimer's disease.
The core legal problem for you, the listener, is really this. If someone's mind, makes them incapable of conforming their behavior to what we expect due to severe mental illness, should they still be held fully liable for any harm they cause? This case we're looking at is a crucial test that asks specifically, when a patient injures a professional caregiver, who actually bears the cost?
That's exactly the tension, isn't it? And for this deep dive, we need to be rigorous. First, we have to lay down the general rule for mental capacity in torts, and as we'll see, it's surprisingly strict. Then we have to apply that rule and all its public policy reasons to the specific, very fact-driven scenario in the landmark case, Creasy v. Rusk. We really need to understand how relationship exceptions can sometimes, override that general rule. Right. Let's start the foundation then, the basic doctrine. Does the law recognize a separate standard of care for adults with mental disabilities? Maybe something more lenient, considering their limited capacity. A bit like how we treat children, perhaps.
Well, what's fascinating here is that the answer generally is a pretty firm no. The majority view, what's often called the restatement rule, specifically restatement second of Torts section 283B, it states explicitly that mental disability does not excuse a person from liability for negligence. They are held to the standard of a reasonable, ordinary person under the same circumstances. And crucially, this is without regard to the alleged tortfeasor's actual capacity to understand or control the consequences of their actions.
Wow. That is strikingly strict. I mean, for our listeners focused on fairness, how can the law justify holding someone liable when they truly, genuinely lack the capacity to form intent or even control their body? It sounds a bit like we're punishing an illness.
It does sound harsh, I agree. But the law here makes a clear separation between legal liability and moral fault. The restatement itself explicitly avoids making allowances for an adult's lack of intelligence or ignorance or mental capacity. Negligence, you see, focuses on the effect of the action on the victim, not necessarily the actor's subjective ability to control it. We're often dealing with the situation of an innocent person, the injured victim, versus another potentially innocent person, the mentally disabled actor. The law has to decide who bears the burden of that loss.
Okay, so the initial focus isn't on the actor's state of mind or capacity, but more on protecting the victim and ensuring they get compensation.
Precisely. And you can actually see this tension play out in the Creasy case itself. The Indiana Court of Appeals, at an earlier stage, they did try to factor mental capacity into the duty determination. They were trying to make it perhaps more equitable for the patient. But the Indiana Supreme Court ultimately rejected that softer approach. They came down firmly, confirming that the black-letter law aligns with the strict restatement rule. For adults, capacity is generally irrelevant to the standard of care in negligence.
That really sets the stage for our main event then. Because the Indiana Supreme Court in Creasy v. Rusk had to resolve exactly that tension. They had to decide, okay, we have the strict general rule, but does it apply universally, even given the unique relationship between a patient and a professional caregiver? Let's bring this rule down to earth. Let's analyze Creasy v. Rusk. First, what exactly happened between Mr. Rusk and Mrs. Creasy that led to this legal fight? What are the legally dispositive facts?
All right. So, Lloyd Rusk was diagnosed with Alzheimer's disease and lived at the Brethren Healthcare Center. Over time, his condition worsened. He developed periods of being extremely agitated. The record shows he was often resistant, belligerent, aggressive, and sometimes combative with the staff. Carol Creasy was a CNA, a certified nursing assistant, working at that facility for nearly 2 years. She knew Mr. Rusk had Alzheimer's. She knew he had been combative before. She'd even been bruised by other Alzheimer's patients. And importantly, she specifically knew he was very agitated and combative that evening. The injury itself happened when Creasy and another CNA were trying to put Rusk to bed. He started hitting and kicking wildly, striking Creasy. This caused a lower back injury, which ultimately led to her lawsuit against Rusk's estate.
Okay, given those really tragic facts, what was the central legal question the Indiana Supreme Court had to grapple with? What was the core legal issue here?
The central issue was this. Having accepted that strict general standard of care for mentally disabled adults, did the specific circumstances here, namely, that the injured person, Creasy, was a professional caregiver who assumed a known risk as part of her job, create a public policy exception? In other words, did those facts mean that Rusk, despite the general rule, actually owed no legal duty of care to Creasy?
Before they tackled the exception, let's be clear. What rule did the court formally adopt regarding the general standard that applies to all adults with mental disabilities in Indiana?
They formally adopted the strict restatement rule, Section 283B. Adults with mental disabilities are generally held to the standard of care of a reasonable person under like circumstances, regardless of their actual mental capacity to understand or control their actions.
Okay, so they adopt this strict rule, but why? What was the deeper reasoning, the policy thinking behind sticking to such a tough standard? Let's get into the court's analysis. Tell us about those 5 core policy arguments they discussed supporting the restatement rule, and then explain why they still carved out an exception for this specific caregiver situation.
Right. The court first carefully laid out 5 pretty compelling public policy reasons that courts have traditionally used to justify holding mentally disabled persons liable, even when they might lack moral fault. First, and this is often seen as the main one, it enforces loss allocation. It allocates the financial loss to the party who caused it, or at least occasioned the loss. So in this case, Rusk's estate pays, not the innocent victim, Creasy.
Okay, so basically it's about deciding who is the better risk bearer financially, even if the person causing the harm didn't, intend to or couldn't help it.
Exactly. It separates the financial consequence from the moral blameworthiness. Second, the court said it provides incentive. The idea is that holding the person liable provides an incentive to those legally responsible for them, like guardians or family managing their estate, to prevent harm, potentially by restraining potentially dangerous individuals.
Wait a second on that one. That second policy point, the incentive to restrain that sounds almost, punitive, or at least raises some ethical flags. Did the court grapple with the tension between that and modern care policies that favor integration and avoiding unnecessary restraint, especially for people with cognitive decline?
They did acknowledge that tension. They specifically mentioned that modern policy favors the least restrictive environment for individuals with disabilities. However, they ultimately decided that the established tort policies, protecting the public, ensuring loss compensation, outweighed that concern in this context. They reasoned that the risk of institutionalization or perhaps increased restraint was, in a sense, secondary to ensuring that innocent third parties injured by the actor's conduct are compensated. It's a tough balance. The third policy is more straightforward. It removes inducement for people to fake a mental disability just to escape liability if they cause harm. Makes sense, right? You don't want to create that loophole.
Yeah, okay, that one's pretty practical.
Fourth, it avoids administrative problems. Courts and juries would face enormous difficulty trying to accurately assess the specific nature, degree, and fluctuation of someone's mental capacity at the exact moment of the incident. Mental illness is complex and hard to measure consistently for legal purposes. And fifth, the court mentioned that it forces persons with disabilities to pay for damage they cause if they are to live in the world. This really underscores that the focus is on compensating the victim, making the person whose actions cause the harm bear the cost, rather than leaving the victim uncompensated.
That fifth point is quite stark, isn't it? Forcing disabled persons to pay just to live in the world. It really highlights that this is purely about economic compensation, completely detached from any notion of fault or intent.
It is entirely non-fault based in that sense, yes. But, okay, after establishing those 5 powerful reasons for the general rule, the court pivoted. They looked very closely at the specific relationship between Rusk and Creasy. Creasy wasn't just some random person walking down the street who got hit. She was a professional caregiver. She was hired by the facility specifically to care for patients like Rusk. She knew about the risks associated with his condition, the agitation, the potential combativeness. It was part of the job description, essentially. So the court reasoned that the public policy considerations shift dramatically when the person injured is employed precisely to manage and deal with the very type of behavior that caused the injury. She was there to protect Rusk and manage these known risks. Therefore, the court concluded that the general rule, despite its strong policy backing, had to yield in this specific context. The unique nature of the professional caregiver relationship trumped the general rule.
And so, the final conclusion. What did the Indiana Supreme Court ultimately hold?
The Indiana Supreme Court held that Mr. Rusk owed no legal duty of care to Ms. Creasy under these specific circumstances. This was because of the nature of their professional relationship as patient and caregiver and the underlying public policy. The court decided it wouldn't be fair or logical to shift the cost of an injury arising from a known risk inherent in the job back onto the patient when the caregiver was specifically employed and presumably compensated to manage those exact risks. Creasy had professionally assumed that risk.
That distinction is crucial. It makes the rule clearer in that professional setting. But let's just take a moment to solidify the strict general rule, the one that applies outside that caregiver exception, because that's the rule that governs most situations, right? Let's use a hypothetical, something visceral to make it stick. Imagine someone is driving. Suddenly they suffer a complete, permanent, and utterly debilitating psychotic break. They have no history of this, it's totally out of the blue. They start hallucinating, vividly seeing monsters on the road, let's say, and they swerve violently into oncoming traffic, causing a terrible accident. They genuinely had zero control, zero understanding of reality at that moment. How does the general rule, that reasonable person standard, treat their liability compared to, say, someone who has a sudden, unexpected physical event while driving, like a first-time epileptic seizure or a stroke?
Yes, this is a really important distinction, and it often trips people up. The law treats sudden, unforeseeable physical incapacitation differently. If a driver suffers a sudden stroke or heart attack, something they had absolutely no warning about, and consequently loses control of the car, they might be excused from negligence. The reasoning is often that there was no volitional act once they became incapacitated. They didn't choose to swerve. But for mental incapacity, even sudden and severe, the general restatement rule that Indiana adopted is unyielding. The driver's sudden lack of intelligence, judgment, perception of reality, or capacity to control their actions is simply not considered in the negligence analysis itself. That driver experiencing the sudden psychotic break is still held to the standard of the ordinary, reasonable, prudent driver who isn't hallucinating. It comes back to those policy goals, especially loss allocation. The loss falls on the driver who swerved, even involuntarily due to mental illness, to protect and compensate the innocent driver they hit.
Wow. So even though from a practical standpoint, both the stroke victim and the hallucinating driver lost control involuntarily, the law draws a very sharp line. The stroke victim might have a defense, but the person with the sudden mental break is almost certainly liable under the general rule. It really drives home that it's a standard of liability, not moral fault.
Absolutely. We hold the mentally disabled driver liable primarily to ensure the innocent victim of the collision gets compensated. It reinforces that core idea. The loss falls on the actor whose conduct occasioned it, regardless of their subjective mental state or moral capacity at the time. It's tough, but that's the rule.
Okay, this is definitely a difficult and maybe even uncomfortable area of law. We've got this very strict general rule and then this very specific relationship-based exception from Creasy. How can we boil this down? Can you synthesize these rules into a practical framework, maybe like a step-by-step checklist for, say, a law student or anyone trying to diagnose liability in these tricky situations?
Yes, absolutely. That's a crucial final step for applying this knowledge. When you encounter a tort problem involving an adult defendant who might have a mental or emotional disability, here's a 5-step diagnostic checklist you should run through. Step 1. Identify the standard. Start by stating the general rule clearly. Confirm that, for adults, mental or emotional disability is explicitly not factored into the standard of care for negligence. The required conduct is always that of a reasonable person under like circumstances. Cite restatement section 283B if needed. Step 2. Apply policy rationale. Briefly mention why the law is so strict. Touch on those core policies: loss allocation, preventing feigned claims, administrative ease, maybe the incentive for restraint, to show you understand the reasoning behind the general rule. Step 3. Check for the professional caregiver exception. This is a critical Creasy pivot point. Ask, was the injured plaintiff a professional caregiver? Think CNA, nurse, attendant, someone employed by a facility or the patient specifically for care. Step 4. Assess assumed risk. If the answer to Step 3 is yes, then ask, was the caregiver employed specifically to manage or mitigate the exact type of known risk or behavior related to the mental deficiency that actually caused the injury? So, if the injury was from the patient's known combativeness, like in Creasy, the exception might apply. But if the caregiver slipped on a wet floor negligently left by the patient, that's different. It wasn't a risk inherent to the mental condition they were hired to manage. The link has to be direct. Step 5. Conclusion on duty. Based on your analysis in steps 3 and 4, reach a conclusion. If the plaintiff was a professional caregiver injured by the very conduct associated with the patient's condition that they were hired to manage, then based on Creasy, the patient likely owed no legal duty to that specific caregiver under those circumstances. No duty means no negligence liability. If not the general rule, step 1 likely applies.
That is a tremendously helpful framework. Thank you. It really clarifies how to navigate from that strict baseline rule to the very specific exception. So, we covered a lot of ground today. We started with the surprisingly strict general rule from the restatement holding adults with mental disabilities to a reasonable person standard. Then we dove deep into Creasy v. Rusk and saw how public policy around professional relationships and assumed risk can create these crucial, very fact specific exceptions. The key takeaway really seems to be know the general rule, but always check the relationship between the parties. Thank you so much for joining us for this deep dive.
My pleasure. And perhaps here's a final provocative thought for you, the listener, to chew on. We talked about how one of the key policy justifications for this strict general rule is that it incentivizes estates or guardians to potentially restrain individuals with mental disabilities to prevent harm. Now think of that. Are we as a society truly striking the right balance here? How do we weigh that goal protecting potential victims through compensation and incentivizing restraint against the equally important modern policy of promoting integration, autonomy, and the least restrictive environment for persons with disabilities, as the Indiana court itself acknowledged? Where exactly should the balance lie between tort law's compensation goals and broader disability rights and ethics? That's definitely something worth mulling over.